Stephen A. Williams, president and founder of the creditrepairshop.com, and in today's video, we're going to talk about the Green versus Portfolio Recovery Associates lawsuit. I kind of touched a little bit on it in a video from yesterday. So if you want to take a look at that video, that gives you some good information about how you can beat debt collectors. Now, one of the things that I want to kind of get your mind in the right direction. And just so you know, Green, she went into court for herself. She did not have an attorney. And this was actually where she had lost and got a judgment against her, and then went back with the information that I'm about to share with you, which is something that I've talked about for years on how you can beat debt collectors. So this is very important. And if can, for me right now, please like this video, because I'm about to help you with this information, and I need you to help other people who might be getting sued by debt collectors, and they need to get this information. So one of the things, when I was reviewing this case and when I was looking at how we've helped people, something came to me it reminded me of being a child. And let me tell you what I mean by that. Is that, have you ever been blamed for something and you know that you didn't do it? That you just know that it's, some of it might be true, but you know that you should not get in that much trouble for what you're being blamed for. This is similar. This is similar to what debt collection companies who buy your debts from original creditors, in a sense, they do stuff like this. And that's why people get where you get a little bit upset, because logically, you know that the debt was yours. You made the debt. But what they don't want you to know is that you have rights and privileges to challenge them on every document that they were supposed to attain, everything that's transferred from the original creditor over to them. You have a right to look at all of that information and to make sure that it was done appropriately, the right way, that there's not something that is manufactured within those documents. Because if something is manufactured within those documents, or something is missing within those documents, the whole case is over. The whole case is over. These debt collection companies know the risk. They know the risk. They just don't want you to know about the risk. So regardless if you owe the debt or not, you can win solely based on making them prove that you owe that debt. Solely if you put everything in order the right way, say it the right way, so the court understands it, and so they understand your argument, which would be in your affirmative defense, you can win these debt collection lawsuits. And you can go to my website and see plenty of them. Plenty. The highest to date is $100,000. One. Outright one. And this even goes to original creditors, and let me show you how that bridge works. An original creditor is not going to be in court representing themselves. They're going to have a debt collector representing them. And that original creditor must get all of the documents to that debt collector, because according to the Fair Debt Collection Practices Act, anyone who collects debt on the behalf of others must go through that entire process of proving, validating, whatever. You can read it and see all of the initial things that they have to prove to make sure you have to pay the debt. And that's even from an original creditor, because the plaintiff attorney, the lawyer representing the original creditor, can't just take their word on it. That's just not how it works. So I want to help you get back to where things are normal in your life. If you got debt collectors coming after you before trying to sue you, or if they are trying to sue you, I know how you might be feeling. Let me turn my computer down here. I know how you might be feeling. You want to get stuff back to normal. You want to, get this off your back. You want to be able to sleep. You want to get your confidence back. Uh, and that's my goal. That's my mission, is to get you the information so you can get yourself back to normal, back into that position, and be able to move forward. So the case is Mazie Green versus Portfolio Recovery Associates. What I did is I'm just going to do tell you a brief summary, and then we're going to go into a little bit of detail on how the specific part of the case, how it broke down, and how Portfolio Recovery, who did win in the lower courts a judgment, how it was turned around and it was all done. They can't even come back and do anything to try to win, to try to sue her for the case. And this debt was debt that they purchased from the original creditor. So you can win these cases. So please pay attention, like the video right now so we can pump this up and have more people watch it. So the case, Mazie Green versus Portfolio Recovery Associates LLC, involved a dispute over a debt collection action. Portfolio Recovery Associates filed a lawsuit against Mazie Green claiming ownership of her debt through a series of assignments from various financial institutions. The lower court ruled in favor of Portfolio Recovery Associates, awarding $8,914.31. So just think, when you get slammed with a judgment from a debt collector who purchased your debt from the original creditors or have been passed down from one portfolio company to another, and it's $8,914.31, and they did not prove beyond and it's not, I don't want to say a reasonable doubt, but they did not prove with all of the documents that are required according to the Fair Debt Collections Practice Act that. So let's go on appeal. Green representing herself. On appeal, Green representing herself. Reason why a lot of people end up representing themselves is because a lot of attorneys. That's why it is blowing up for companies like mine to be able to help people with this, because a lot of attorneys just don't want to deal with this. That's just the way it is. A lot of attorneys just don't want to deal with this type of stuff. If they did, you would see commercials all over the place. They mainly want to do big time class action if it comes to this type of stuff, or they want to do, where people are criminal or personal injury. That's just where it's at for them, unless they're in entertainment or something like that. So Green represented herself. She argued that Portfolio Recovery Associates lacked the standing to sue because they could not sufficiently prove ownership of the debt. Virginia Court of Appeals agreed, noting that the documents provided by Portfolio Recovery Associates were insufficient. I'm going to get into detail about what the problem was with those documents, and I've talked about it a lot in other videos, and I think it's worth repeating it again. And we have a case right here, recent case, so you can actually see this, that it is true what I say, because sometimes you got to get that extra validation to make sure that what Steve is talking about is true. And I always say, trust but verify. So whatever I say, you can trust it, because I'm not going to tell you nothing that I haven't done or done for clients or researched. And you should verify. So and really the verification is so you can internalize it. You can read it. You can, if it's a book, you can fill the book and internalize the information. So the Virginia Court of Appeals agreed, noting that the documents provided by Portfolio Recovery Associates were insufficient and failed to establish a clear chain of title for the debt. Remember, I've always talked about, you can win these cases by their own documents. Like, a lot of people start trying to quote other cases and, like they're an attorney and stuff. Don't do that. Don't do that. Look at their documents. The best way to tear apart a debt collection lawsuit is by their own documents, or lack of documents, or problems within their documents. That's how you can beat them, because then they presented their evidence, and their evidence is flawed. So what do you think they're going to do when you point out to them in the court that their evidence is flawed? That's why when we've helped our clients, a lot of the debt collectors will dismiss before the hearing. They're like, we got trouble. What do you want to do? Dismiss it. Or they'll say, keep it going, because we don't believe that they might they may not show up in court. If they don't show up, then you go get the default judgment. If they do show up, immediately dismiss it. Don't even let them say anything. That has happened for clients where they stood up, called her name. Okay, come on up. On the way walking up to to where you go to sit in front of the judge, the plaintiff attorney said, dismiss, case dismissed. They were just making sure that the person was there, so because they didn't want to give away that easy default judgment that they could have got. So the appeals court highlighted that none of the bill of sales contain Green's name or account number. I've said that over and over and over and over and over again. I've said that over and over and over again. When you look at the bill of sale documents, on those bill of sale documents, it never has your name, never has the complete account number. It doesn't have any of that stuff. So how can they have one document and they say that this document is about you, and then it doesn't have your information on there? Now, I know what you're already thinking. Portfolio Recovery Associates attorney, through one of their employees that is supposedly handling all of the documents, said that they don't have it on there because they don't want to reveal all the names that they purchased. BS. They get away with it because no one challenges it. No one, except for when I looked at it, when I first figured this whole thing out, I looked at the bill of sale and I was like, something is missing. I was reading it and I was like, something is missing. And what's missing is the individual's information. How can you buy something from someone and just say portfolio on there and some digits, and you don't, and then you go after someone and say you were included in that portfolio? And if you've ever looked at what the portfolio looks like, you would be like, man, I do not agree with this. But see, no, people don't challenge them 100% on this. You got to go at them, and if you go at them and you challenge those documents, they're going to end up dismissing your case, or you're going to just get it dismissed by the judge. You're going to win your case. So, did not have Green's name or account number, making it difficult to tie the debt specifically to her. Consequently, the court overturned the lower court decision and ruled that PRA did not have the right to collect the debt from Green. Now, when it states lack of standing, I wanted to kind of clarify to get some legal clarifications on what the court means by lack of standing. Legally, lack of standing means, so this will help you when you craft your affirmative defense, if you decide to do this type of stuff yourself, or you can reach out to us, have us do it, and you can just, see the work and see how it's done. Lack of standing means that the party does not have sufficient connection to and harm from the law or action challenge to support the party's participation in the case. To have standing in a legal context, a party must demonstrate. And it uses the word injury, but it's going to be different when it's with debt. But I guess they consider it just, this is the way that it's explained legally. It says injury, in fact, a concrete and particularized injury that is actual or imminent, not hypothetical, which we could say that if they have a document, a bill of sale, does not have the name or the account number, that's going to be hypothetically, you're saying that she's involved with that purchase of that portfolio. Hypothetically, because it's not there. You have to just say, we're going to go off of what you said rather than the documents that you felt that your signature had to be on. You felt that it had to have your name and who you purchased the debt from, but you didn't feel that it had to have the name of the individual that you're trying to sue for the debt that you purchased in that portfolio. So that's the problem, and that would make it hypothetical. Causation, a direct link between the injury and the conduct complained of. Goes again with the documentation. You got to prove. And then also, just to add on to that, what I personally see with these cases is that They will give you documents that will have different balances of amounts, and then they have an amount that they're actually suing people for. So if you just look at the documents right there that they gave you to try to prove the amount that they claim that you owe, and it's with certain statements, and they're like, well, these statements don't even add up to that. There was one, a gentleman sent one over yesterday, and he was using one of the law centers to help him with his case. And he was just like, hey, can you just at least take a look at this? And I said, right away, here's the problem that I see with your documents, is that they're coming after you for a certain amount of money. And within all of the documents, and the gentleman said, he felt in his email, he typed, something does not look right to me, because he's looking at the documents, he's looking at the amount they said he owed. He's looking at the documents, he's looking at the amount they said that he owes. He looks at the documents, looks at the amount they say he owe, and it's different on all three documents, and it never gets to the amount. It never gets to the amount that they claim he owe. Had another individual contact me, show me the documents. I was like, he said documents were zero. Like, it specifically says I owe no money on the documents that they gave on the statements. And I was like, send me the statements. Let me just look at it. Sent the statements over to me. 3 statements that the debt collection company who is trying to sue this individual right now, it on 3 statements it says balance owed 0. But they're trying to come after him for, I think, $1,500 to $1,700. But on the 3 statements that they put within the lawsuit, the exhibits in the lawsuit, the statements, it says 0 balance. The reason why they do this is they don't want you to pay attention to this stuff. People never really paid attention to this stuff, and that's why they were always able to get away with it, because most of the cases end up in default judgment, or even if a person goes to court, they have no affirmative defense set up for them to challenge the case that is against them. They're just standing there saying, I don't know, or I don't admit. Like what all of these software companies are telling people to do, just don't admit, and then you get up there and it's like, okay, what do you got to say about this? You're not going to just be up there to go up in there and say, I don't admit, and then they're going to present their documents. They're going to say, well, it makes sense to me. The judge can say, it makes sense to me. If you had an affirmative defense against those documents that they already gave you 20, 30 days ago when you were served, you could have stopped all of this stuff a lot earlier. The next thing is redressability, a likelihood that the injury will be redressed by a favorable decision. The reason why is because it's not going to be. So lack of standing on this, because the documents, they're all mangled with issues and nothing with her information on the bill of sale. And there were other issues that were also in there. That's why it's very important to know your specific case. Her specific documents were passed down from 4 or 5 different creditors and debt collection companies. Like, you can read the case and you can see that it was a lot of issues. So if the parties cannot establish these elements, the court will dismiss the case for lack of standing. The principles ensure that the court only adjudicate actual controversies where the parties have a genuine stake in the outcome, thus preventing courts from issuing advisory opinions on hypothetical disputes. In the case of Mazie Green versus Portfolio Recovery Associates, the court found that Portfolio Recovery Associates lacked standing because they could not sufficiently demonstrate that they owned the debt in question, thus failing to establish a direct and specific harm caused by Green's alleged non-payment. All right, if you have debt collectors who are suing you in court, there's a link below my video. Go to my website, thecreditrepairshop.com. Let us review your documents. Let us review your documents, and we'll tell you straight up what we believe, or how we believe we can help you. or we'll just give you some information. It's up to you. We understand everybody's situation is a lot different, but you do have options. So I don't want you to feel trapped that you don't have options. If you have debt collectors coming after you early in the game, grab my 3-pack of letters. You always just check the statute of limitations, because you may not have to pay the debt because of the statute of limitations. If it is past legal statute of limitations, you do not have to do a debt validation. You just have to notify them. Cease and desist collection activities letter and debt validation letter is part of my 3-pack. Those, the cease and desist collection activities letter is to actually start in a way, if they are going to try to sue you, you're going to make them reveal documents ahead of time. And when they know what you're trying to ask for, that they potentially have problems, because at that time, one of the requests that you're going to make is that an attorney reviews it. Attorneys do not review debt collection letters. I don't care what you've heard anywhere. I don't even care if you heard it from a debt collection attorney. Any letter that is sent out from a debt collection law firm that has their information on there has never been, I won't say never, but more than likely has not been reviewed by the attorney. It's just a demand letter that is being pumped out there to try to see if they can get any action from you. So when you do this, it's going to force them to have to make a decision on if they're going to come after you. They might decide to go ahead and come after you because, again, they're in the business of trying to make money, and most people don't follow through. Most people don't show up to court. Most people don't have a defense against what they're doing because they don't know how to put together an affirmative defense against what they're doing. They don't know how to check the documents. They don't know what to look for. So they're going to gamble on the person either not showing up or not knowing what to look for. And then they're, end up getting the judgment and garnishing wages or taking money straight out the bank account. There's a link below here. You can get those 3 documents. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. That's the way that we repair credit and help people increase their scores. If you need your credit reports and scores, go to the website, your3scores.com, to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. That is where everything starts. Thank you for your time. Subscribe to the channel. Post your questions and comments. Give yourself a hand if you're still watching. Keep moving forward. Thank you for your time. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.